Oh yes, oh yes, oh yes. This Honorable Court of Criminal Appeals of the State of Tennessee is now in session. God save the United States, the State of Tennessee, and this Honorable Court. Please remain standing.
Thank you, Madam Clerk. I think all of you who are in this courtroom are aware that since the last call of this docket, we have lost a colleague on our court, and I wanted to take just a moment this morning to remember Judge James Kerwood Witt, Jr. He passed away on August 17th. He was a resident of Monroe County, Tennessee. At his memorial service a couple of weeks ago, our former colleague and senior judge, Kelly Thomas, led us all on a call to court that I would like to do this morning as well in honor of Judge Witt after we take a few moments of silence, please. All rise. We stand to honor and recognize James Kerwood Witt, Jr.'s outstanding service to the people of the state of Tennessee as a judge of the Court of Criminal Appeals for 27 years. May we all pattern our legal careers and civic lives after his. Judge Witt's docket is now complete. Thank you. You may be seated. On behalf of our presiding judge, Camille McMullen, and all the members of the Court of Criminal Appeals, I thank you for allowing us to take that moment to honor Judge Witt, who is a good friend, colleague, and just a real Renaissance man. Thank you for that. This is the docket for September 2024 in the Western Section of the Court of Criminal Appeals. We're happy to be here this morning. You have today, and I'm honored to be able to sit with what I call a grand panel that we occasionally have on the Court of Criminal Appeals, and that is where you have a representative from each grand division on the panel this morning. Hearing the first case with us, to my left and your right, is Judge Matt Wilson of the 26th Judicial District here in Madison County, Tennessee. Judge Wilson has been a member of this court since March of 2023. To my right and your left is Judge Kyle Hickson of Knox County, which is the 6th Judicial District. Judge Wilson's been a member of this court since 2022. Glad to have you. And my name is Tim Easter. I'm from Williamson County, which is part of the 21st, well, is the 21st Judicial District now. Back when I was there, we had other counties, but now it is the 21st Judicial District. And as of a couple days ago, I've been a member of this court for 10 years, and we're honored to be here this morning. Are there any preliminary matters, Madam Clerk?
No, Your Honor.
Okay, I know we're taking one case out of order, or original order. If you'll go ahead and call that case, please.
Stephen Skinner versus State of Tennessee.
Mr. Tootin, I remind you and all the parties here this morning that each side has 20 minutes, as you're aware. If the appellant would like to reserve some rebuttal time, please let me know when you approach the podium.
Yes, I would reserve 3 minutes rebuttal.
Okay. And we do, actually, as you know, exercise the light system here, so
Yes.
3 minutes for rebuttal.
Thank you, and good morning, Your Honors. May it please the court. It's a pleasure to see everyone again today. I am Attorney Tootin on behalf of Stephen Skinner, the appellant. I'll jump right into the meat of this argument. Some of these things that are being raised in this brief, the evidence that we're saying is new evidence, I will be candid with the court. The court has seen some of this information and evidence before in prior rulings, and that's because the documents listed that is being described as new evidence was previously presented, I believe, in the 2020. Stephen Skinner discovered this information, I believe, through the Freedom of Information Act. He then tried to do a writ of error coram nobis back in that time. The problem he had is that he did not receive an affidavit from his trial counsel. His trial counsel would not give him one. And so what he did to try to make it fit or to qualify is there was a call, a jail call between himself and the trial counsel, where the trial counsel admits that this evidence, he didn't have it before. If he had it, he would have used it. And so at that point, Mr. Skinner did not want to risk his evidence being time barred. Once he had that admission, it was his trial counsel's actual voice, so there was no question about who he was talking to. So he submitted the evidence at that point, and that appeal was not successful because it was determined that that was not sufficient, that the audio, the voice of the trial counsel was not sufficient as a written affirmation from trial counsel vouching that the evidence was new. So that was part of the issue. To address part of the argument that the state raises in its brief is they seem to suggest or believe that, well, why didn't he just get an affidavit from his trial counsel? He was not able to. And in fact, Sharon Fortner at the time, who was his attorney, on oral arguments, which is preserved for this court to review, addressed the court and told him candidly that the trial counsel would potentially testify at a hearing if he was called to testify, but he would not give an affidavit in writing. That's also consistent with Mr. Skinner, who, when he applied, he did an affidavit. When he did his petition, he did an affidavit saying he couldn't get this information.
So what was the date of that first action? Are you referring to the writ of quorum nobis or the?
Yes, it was.
Okay.
It was in 2020.
2020, and you're saying that was timely?
So back. I guess we'll back up. When he got the evidence, he filed it within a year of receiving it, which was when that process happened. So if we're saying from the time of the case when it started, from when he got the evidence, it was already after the statute of limitation, already after the post-conviction, is he didn't discover it until later through some Freedom of Information Act, as I read, that appears as how he had got it, and he filed it within a year of getting that. The problem he ran into is it was denied because it was determined that although this, basically the court ruled, and again, I don't want to misstate anything, I know the ruling will speak for itself, but I understood it, the court's ruling to be that if your trial counsel has not given some type of written affirmation that this is newly discovered evidence, how do we know in fact that it was new? Because previously the trial counsel also said he had all the evidence. He didn't define what that meant, and it was obviously Mr. Skinner's understanding is that he believed, meaning the trial counsel had his evidence at that time, but he was not aware of this other evidence, and that was supported by this audio jail call between the trial counsel where they're going through these documents, and trial counsel admits, I did not have that, and if I had it, I would have used it. However, that was not sufficient in 2020 on the appeal to be successful because there was no written affirmation, was just the audio recording. So essentially what Stephen Skinner was trying to argue is, can this audio recording be equivalent to a written document from trial counsel saying this evidence was new? And the ruling, unfortunately, was no. So then what ends up happening that makes this ripe at this point is there ended up being correspondence and there ended up being a board complaint. And then finally, for the first time, there was written affirmation from trial counsel admitting that the evidence was new because the complaint listed all the documents again to say this is, basically he complained that he won't even write an affidavit for me. He won't even basically acknowledge this. He's keeping it in secret and it's to my detriment. And then by being forced to respond to the board complaint, he finally got his written affirmation from trial counsel acknowledging that the evidence, he did not have it, and that if he had it, he would have used it. Trial counsel seemed to make the suggestion that myself and Attorney Fortner was telling him that he needed to say that the state withheld it intentionally, and his argument was, well, I'm not saying they held it intentionally or not, I'm just saying I didn't have it. To be clear, Mr. Skinner wanted him to just admit he didn't have it. There would have been a hearing to determine who was at fault or things of that nature. I believe the state seemed to latch onto that and say, well, he would have always given a statement. He just didn't want to say it was intentional. I think the record supports from the affidavit from Mr. Skinner as well as the oral arguments from Sharon Fortner. He was never willing to give that statement prior to having to give it to the board. And again, a hearing would clearly flesh that out, because if there's a hearing and it was determined he was willing to give the statement the whole time, then obviously there would be a time bar issue. The reason it would not be a time bar issue here is because that evidence leads and deals directly with actual innocence. I mean, these are documents that talk about, for example, Michael Brown, one of the key witnesses for the state, they said that Mr. Skinner ordered this hit, meaning 2 individuals were killed. they said was a gang-related crime and that Mr. Skinner ordered the killing of these people. He was convicted because Michael Brown then got on the stand and testified that Mr. Skinner ordered the killing of these people. He found later, now for the first time as his evidence, where Michael Brown actually says the opposite, that Mr. Skinner did not order the killing of these people. And then in addition to that, he has information now that shows that Michael Brown testified in federal court saying that someone else actually ordered the killing, and those other parties, including Michael Brown, were convicted based on that version, that someone else did it. So the concern is this evidence should have been made available.
So, Mr. Tootin, wouldn't that information just be used to impeach Brown?
I don't know if, well, I mean, it could be used to impeach Brown as well as support actual innocence. But even now, as we sit here, because of the filings, it's been a lot of time passed, he has now had a affidavit in another previous appeal that is now part of the record where the court can take judicial notice of, where Michael Brown is now given an affidavit. And in the affidavit of Michael Brown, he acknowledges and says, I felt pressured to testify this way, that I told the state that this is who really ordered the killing and that Mr. Skinner did not, and they continued to pressure me, and then I said this, and now I regret it. I should not have done that. So that not only does it impeach, but it goes towards actual innocence, and it goes towards the fact that the state had this information and documentation. The other issue that could that I think I'll address it because it needs to be raised for this court to flesh out, is the argument would be, and again, if it hasn't been made, I'll make it in candor, is that if there was a federal case where there was a federal trial where Michael Brown testified this way, and that the trial counsel did not have that information previously, he admitted that he never got it from the state, and as our contention that they were required to provide that to him because that's exculpatory. To the extent the argument is, well, couldn't trial counsel himself had figured out what was happening in the federal prosecution? I don't know. That's something I think we absolutely need to have a hearing on to determine what type of information was available that he had access to. But the fact that he did not get that information that was clearly exculpatory and outcome determinative also falls back on trial counsel. So I think it's twofold. We have one issue of the state potentially withholding exculpatory evidence, and the only question being, was it intentional or an oversight, but with there being no question that they withheld it. And then there's a second issue as to whether trial counsel should have figured out how to get at least some of this evidence, clearly not all, but some of this evidence specifically relating to Michael Brown testifying as a key witness, saying someone else ordered the hit, not even arguing that Mr. Skinner and someone else ordered the hit, just completely saying someone else did it in federal court. That goes to the other issue that we raised in here, which is that motion for our post-conviction. It gets a little gray because typically when you try to reopen a post-conviction, you're looking at, was there DNA? Did the law change of things of this nature? I don't know if this necessarily qualifies as reopening a post-conviction as much as an extension of his same post-conviction. Because if the conclusion after we have this, hopefully remanded, and there's a hearing, and the conclusion is, trial counsel, you were asleep at the wheel. You should have been able to, maybe there's some evidence you couldn't have got. There's certain documents that was with the state's file, we get it. But you should have been able to figure out what happened with Michael Brown testifying in federal court. Well, that goes directly.
I'm sorry, Mr. Tootin, but when was Mr. Brown's federal testimony in relation to Mr. Skinner's trial?
I don't recall the dates. It was before. I don't want. It was before. Michael Brown testified in federal court first, and then he testified in the state court second. But I don't remember the dates right off.
Okay.
But it did happen first in time. So I just want to be candid. There could technically be the argument of, well, shouldn't that been the trial counsel responsibility? I think it was the state's responsibility because they had the information and they were using this guy as a witness. They knew how he was testifying. I think they had an obligation to tell that to trial counsel. I do not know how that access and how that worked back then, as far as how, I know things are very easy to access now, maybe not so much then. I think there has to be a trial or a hearing on that, because to the extent the state just hid it That's different than if the state forgot to tell trial counsel, and that's different if trial counsel could have simply accessed the information and didn't. But all of that is not Mr. Skinner's problem or fault. Clearly it's his problem. But that goes to the motion to reopen. Again, whether it's technically reopening a post-conviction, I think it's more along the lines of extending his already timely filed post-conviction to put on this testimony, because that's the heart of ineffective counsel, or that's the heart of prosecutorial misconduct. Until we have a hearing, we can't flesh out which is which, and the most that trial counsel is willing to tell us right now is that I didn't have it. If I had it, I would have used it, and I'm not willing to say whether it was or was not intentional by the state.
Mr. Tootin, how do you respond to the state's argument that we don't even have jurisdiction on the post-conviction side of this?
I disagree, and I would cite to the case I previously cited to, which is Whitehead v. State, which is 402 Southwest 3rd, 615. I believe in pages 623 to 624, it talks about extending the statute of limitations, and it talks about claims of relief that arise after the statute of limitation has expired. And it then goes on to say that although the Post-Conviction Procedural Act may be constitutional on its face, there's ways it can be implemented that has an unconstitutional effect. I believe the phrase they use is that the defendant found himself, in that case, in a procedural trap, I think is the way they phrase it, where they say, look, although the act on its face is not on its face unconstitutional, but there are scenarios where due process can be violated. And so they carve out a lane to say, this, we need to address it. So I think it's a timely filed post-conviction. I think at a minimum, if we're going the post-conviction route, because I think we have to do both, that he needs an opportunity to be able to put that, his trial counsel on the stand, because this is in essence, the heart of his argument of post-conviction. Even trial counsel stated in the post-conviction testimony, the first time, that his case hinged on if Mr. Skinner did or did not order the hit. That's his trial counsel in his own words saying, this is the crux of the entire case here. So it would not be fair under, I don't believe, any scenario due process to have this type of information not argued or being able to be addressed by Mr. Skinner. What would be the point of a post-conviction if he can't use evidence this strong to show ineffective counsel? But again, I think it comes down to how did this evidence go about getting kept from Mr. Skinner? I don't think it's good practice to allow evidence to be withheld. We all now know it was withheld, and then turn around and say, too little, too late. In this proceeding, as is pending, the trial court, current trial court that heard this, actually said on the record, and I cite to it, we know that trial counsel didn't have this evidence, Mr. Tootin. Like, basically, move on. We know that. And I don't think what trial counsel was, or the trial court was understanding is, no, that's my whole point. It was not that, it's clear now. It was not clear up until now, which is how he had to keep coming back, fighting and fighting all these years for his life. He's tried to comply with everything this court has said. Each time he found a hurdle, found out there was something he didn't do, found out there was something he needed, he never gave up. He kept digging, he kept looking, and now he has presented all the evidence the way it was asked to be presented, and he's just asking to be heard on it. I think that a trial counsel, the hearing has to be done, because I think the record would be clean and be fair to all of us if trial counsel can go through each document that was withheld and then explain the importance of that document or lack thereof. And so then we can have a clean record on, this is the evidence I didn't have, here's why I would have used it, here's how it would have had an impact, and then there could be a ruling to determine, okay, was this material or not? I cite to the brief and make it clear it's extremely material. It proves actual innocence, but just so that the process is clean, let him testify under oath. If he's saying whatever he needs to say, let him defend himself, explain it, and then let Mr. Skinner have a completed post-conviction hearing where he can ask him about this, because it clearly rises to ineffective counsel, which would support why trial counsel would not want to give an affidavit saying that. But this is the heart of the case. And at a minimum, if it's not based on new evidence that the state withheld it, it would clearly be based on the fact that trial counsel was ineffective for presenting it. Either way, it would get Mr. Skinner right back to where he would need to be, a new trial on this where this can be heard. It's really just a fight of who's at fault, but the conclusion would be the same.
Well, help me out. So the open records request 2018, is that right?
I believe so.
Okay,
Somewhere like 17, 18, somewhere in there.
All right, within the 1 year,
Yes.
right? And nothing was done then as far as the petition for post-conviction or the writ of error quorum nobis at that time?
No, it was done then, and it went through the process. By the time it got to the appellate court, it was 2020 when it was filed on this docket. But he did it within 1 year of the open records request, submitted an affidavit to that effect, but it was not considered new evidence because he had no written affirmation from trial counsel vouching for him that trial counsel didn't have those things. All Mr. Skinner had, understand I'm in rebuttal time, all Mr. Skinner had was an audio recording, which was the best he could get because, as Sharon Fortner testified in oral argument, trial counsel would not give him anything in writing. But it would have been timely. It would have been after the year, but timely within a year when he got it.
Thank you, Mr. Tootin.
Thank you.
General Douglas?
Morning, Your Honors.
Morning.
May it please the court, Davey Douglas on behalf of the state. This court should affirm the dismissal of the quorum nobis petition because the petitioner has not presented newly discovered evidence of actual innocence. And this court should affirm the dismissal even if it gets to the issue of the motion to reopen the post-conviction petition, because this court actually doesn't have jurisdiction to consider it. Even if it does, the petitioner has not satisfied the criteria for filing a motion to reopen. But turning first to the quorum nobis petition, it seems like the parties are actually almost in agreement about one thing, that pretty much all of the evidence that is alleged to be newly discovered has already been considered by this court. It's been the subject of Mr. Skinner's 3 prior unsuccessful petitions for writ of error quorum nobis, and the evidence that's at issue here isn't the new letter from trial counsel, it's the underlying evidence. It's the statement from Michael Brown, the other items that were referenced in Mr. Skinner's petition, and that this court has repeatedly considered in Mr. Skinner's prior quorum nobis proceedings. I believe in his most recent proceeding, which was in 2023, this court concluded that Mr. Skinner was not entitled to due process tolling, but then it went further and addressed the merits of the claim. It considered all of the evidence, including this affidavit from Michael Brown, and it concluded that Mr. Skinner was not entitled to quorum nobis relief. And if the evidence is not enough to entitle him to relief on the merits, it is not enough to demonstrate his actual innocence so as to toll the statute of limitations. Another issue about this evidence is it all largely would have been, to the extent it was usable, would have been just for impeachment purposes. And what this court has said is that evidence that merely impeaches, it does not demonstrate someone's actual innocence so as to toll the quorum nobis statute of limitations. And I think more importantly, this evidence has been considered by federal courts in Mr. Skinner's petition for writ of habeas corpus. It's been considered and addressed by this court on multiple occasions. He simply has not carried his burden of showing that he has newly discovered evidence of his actual innocence. And then turning briefly to the motion to reopen the post-conviction proceedings, the petitioner failed to comply with the requirements here in that there was no application for permission to appeal filed in this court after the denial of the motion to reopen. It was instead a notice of appeal, and it didn't have the required documentations or the required documents from the trial court. And it just wasn't sufficient for this court to consider it or to construe it as an application for permission to appeal. So this court doesn't have jurisdiction even to get to that issue, but even if the court wanted to get to the issue here, the petitioner simply has not satisfied any of the narrow criteria for filing a motion to reopen. And Whitehead does not afford him any relief. That was a case where the Tennessee Supreme Court addressed the issue of tolling of the statute of limitations in the post-conviction context. It did not say anything about filing a motion to reopen or to continue a post-conviction petition. And here the petitioner's already had his opportunity for post-conviction relief. He filed that petition and it's been adjudicated. This is not a continuation of his ongoing post-conviction. This is an attempt to reopen post-conviction proceedings, and the petitioner has not met any of the criteria for reopening a petition for post-conviction relief. And unless there are any questions, we would ask this court to affirm the judgment of the trial court. Thank you.
Thank you, sir. Mr. Tootin, you have a few minutes left, I believe.
I'll address the last point and start it first. So this issue about the post-conviction saying that there was no application or procedurally it's improper, I think that argument is not an argument this court should give much weight to, because quite frankly, in this case, if the court recalls, there was a request to consolidate these matters to be heard, meaning instead of doing the typical application because of the timing of the ruling, Mr. Skinner, on behalf of the appellant, we requested that this all be consolidated. The state agreed, and then this court ordered consolidation, so it would be all heard together. So there is no issue about whether or not it's properly before the court.
So is that your argument, that the fact that we consolidated these two issues somehow gives us jurisdiction?
So our position is you already had jurisdiction, but to the extent that there's a suggestion that there was no jurisdiction, I believe the argument that there's no jurisdiction is based on this belief that we didn't do some type of application process separate from the notice of appeal. Well, you don't do an application process if the state has said, let's have this merged and consolidated to be heard at the same time, brief it all together. The real issue would then be, did we timely file the notice of appeal and then timely raise these issues for consolidation? The answer to that question is yes, we did. And again,
why weren't the provisions of 40, 30, 117C followed in this case?
because these were consolidated to be heard together. And again, this is not truly a motion to reopen where it would be based on DNA evidence or the law changing, which is what we've acknowledged on the front end. This is based on the fact that there was a timely post-conviction that was not fully heard, and under Whitehead, which I respectfully disagree, it does provide relief, where it's created a procedural trap for Mr. Skinner, and that there is, on its face, no other way for him to get to the due process of being able to address this issue. So the candid answer is because it's not simply just a motion to reopen a post-conviction, because it's not based on DNA. We acknowledge that. It's not based on a change of law. It's based on the fact that he started a timely post-conviction and has evidence that he never fully got to address in the post-conviction, and that it's a procedural trap because the way the Post-Conviction Procedure Act is set up, he doesn't have any other way to secure his due process. And when asking to have this consolidated to be heard after timely filing the notice, the state agreed to it. So I think it would be different if this was a DNA issue or something to that effect. So that would be our response to that. And again, this evidence doesn't merely impeach. I think that's word games and word semantics. When you have proof to show that you're actually innocent, yeah, that might impeach the person, but it also proves actual innocence. It's more than just impeachment. And the evidence was not already considered. In fact, it was denied to be considered because it wasn't filed as newly discovered evidence with affirmation by trial counsel. So for those points, we ask you to reverse. Thank you.
Thank you, Mr. Tootin. Thank you both. We'll take the matter under advisement and issue an opinion straightway. At the moment, we're going to take a brief recess.